day. If it's Thursday, it must be webinar time. Welcome to the Hines Legal webinar. I'm Chris Irons, Strata consultant with Hines Legal and former Commissioner of Body Corporate and Community Management. With me, as always, Frank Higginson, partner, Hines Legal. Frank, welcome.
Hello, Chris. Hello, everyone. And I'm a bit cold today, so I'm rugged up.
It is a bit chilly and yucky outside, isn't it? Yeah.
Mm-hmm.
Frank and I are coming to you from glorious lockdown today, of course. But I'm assuming that many people watching us and watching us later on will also be in lockdown. He says, putting his phone on silent. So I hope that if you are in lockdown today, you're doing all right and it's not too terrible, and hopefully it'll be over soon. Also today, Frank, it happens to be the 1st of July, which means that we have a brand new, well, sort of brand new in the case of today, a brand new set of webinars coming up for July. We've got some doozies in there. We've got some really good ones coming up this month, which I've got to say I'm looking forward to. Yeah,
we're going a little bit off the reservation, which is good. And I suppose I should start by wishing everyone a happy new financial year.
I think you mean EOFI, don't you?
EOFI, not EFS. Yeah. Foxtel coined that one, didn't they? EOFI?
Yep.
Happy EOFI.
Could be. So yeah, as always, everybody, please register for events. That's where you'll get to find out about what is going on. You can shoot us through questions today and also afterwards, and we will get to those too. But today, Frank, it is deja vu all over again, isn't it?
Thank you, Yogi Berra. Yes, so we're still, I suppose, not what you would call professional presenters in the sense of maybe the content is, but sometimes the background isn't. So the webinar we did on bylaw enforcement in a meeting room with probably poorish Wi-Fi and probably even more poorish microphones is going to get redone today. So we've had a sort of live run through. So this will be a little bit more polished, but Chris, I don't think we can share the chart today, can we?
No, we can't. So in the last webinar, we referred to a flow chart, and we will give you the link for that flow chart towards the end of today. But and I suppose actually the flow chart might even get a bit distracting from the information anyway, Frank. So we'll refer to it, and I'll explain what we mean by that in a second. But yeah, we're keen on dishing out a quality product every week, both in terms of content and in presentation. And yeah, we weren't overly thrilled with that last one, we did. So today we are redoing bylaw enforcement. And to be frank, pun intended, it's the sort of thing, isn't it, Frank, that probably warrants a second go around, isn't it?
It is, and it just comes up so often. You know, it's sort of the, I think probably the caveat with these things is it's a drawn out and cumbersome process. There's no ifs, buts or maybes about that. And I suppose in a sense it should be, because really, you know, you look at almost anything else in terms of, you know, and it really is a litigious style process. So in a piece of litigation, if I'm suing Chris or Chris is suing B, we don't live together. We're not in the same cloistered environment that might be a community title scheme, could be in different states, don't see each other, all that sort of stuff. So bylaw enforcement is not that, because really if you're talking about having a crack at someone in relation to bylaw enforcement, it's going to relate to an occupier or an owner that actually lives in the place where you're having a go at them, because that's where 99% of it's going to happen. So you're effectively attacking the people in their own home, which at the very start is not an unemotional place to be. So when it comes to issues that come across our desk, and I suppose, Chris, back in your day as Commissioner, bylaw enforcement is a lot of what we deal with. And right. Talking people off the ledge, helping people manage the issues and all that sort of stuff is well and truly part of the program. But it's not just a tick and flick and a purely unemotional exercise for those people involved. And that's either the committees or the lot owners that are trying to enforce things, or the people on the receiving end of it. So it's a really important topic.
That's right. And the reason why it is because bylaw is the primary tool by which a committee can manage what goes on in the building. And it's probably the only really valid way of managing conduct and behaviour. In the vast majority of cases, there's no way of regulating behaviour on a community title scheme. Bylaws are the one way, perhaps nuisance as well, that you can do that. So that's why it is so important. One of the other reasons is it's important to go through the steps of bylaw enforcement in some detail is because if you don't, then the whole thing collapses and you go right back to the start. What do I mean by that? The legislation has what is called a prescribed process to go through. By prescribed, and whenever you hear the word prescribed in a legislative context, that means pretty much, Frank, you must follow it literally, black and white.
Follow the rules. It's a roadmap. And if you don't stay off the road, and if you go off the reservation, really what you're attempting to do is going to be knocked on the head to the extent you want to go and follow it through and get an order from an adjudicator seeking that the bylaws be enforced. Because it's a very structured process. And I suppose that's what the flow chart that Chris will link later on shows is what must happen step by step.
And it's so frustrating. I saw it many times as Commissioner, Frank, so frustrating when either an individual or a body corporate takes a bylaw enforcement action, thinks that they've done it the right way, thinks that they have done what they're required to do, only to get right to the end of the process and find out they didn't. And as I say, the whole thing stops because of that. And they've wasted probably a year and a lot of money and a lot of effort into the process. So you might think it's convoluted, you might think it's a whole lot of legal mumbo jumbo gibberish, whatever. I can tell you, you need to follow the steps.
And it's the only process. That's it. So again, if you want to get involved in changing the process, then, you know, legislative review is where that's at, and talking to government about it is your chance now when they're actually looking at reviewing the Act, which is one of the things that'll be coming after this first stage of the working group. But by the same token, there is, you know, a fair degree of natural justice that needs to go with these things. So if you're throwing an accusation at someone, they've got to have a chance to remedy or address that accusation. And that's what the bylaw process or the bylaw breach process creates. There's no bylaw police out there. You know, I mean, I suppose if I'm dealing drugs from my house, the coppers will come and arrest me. In a body corporate context, the only way to actually deal with behaviour like that is through a breach of bylaws. And there is a structured process for that. So, you know, I don't think you'll get arguments from either of us that it's not necessarily fit for purpose in the sense of getting immediate relief from people that might not be doing the right thing, but that's all there is to it. There's no ways around it. There's no self-help remedy for bylaws. You can't go and do them yourself in the sense of enforcing them yourself. You need to have it sanctioned by an adjudicator in the Commissioner's office if you are going to do it. And I suppose, Chris, I mean, we're sort of warning people about the difficulties of this process, but that's one of the things in this month's newsletter, in terms of us writing, that was as much as the legislation's all about self-governance and allowing people to sort of be in control of their own destiny, it's difficult. It's complicated. The new modules make it even more so. So what the Commissioner's office has produced, I suppose when you were Commissioner, is that flowchart and checklist and that sort of thing to help people get to where they need to go.
Yeah,
if they're going to go down the bylaw process.
That's right, Frank. And I remember when I was Commissioner, we did that. One of my staff had the idea to create a flow chart about bylaw enforcement because it can be very confusing. I can tell everybody watching, it took a long time and a lot of work to get that flow chart right because there were so many steps and it had to go through pretty much every part of my office at the time, including adjudicators. So I think you should definitely place some faith in that flow chart. We're going to go through it in a few steps and we'll give you the link to it towards the end. I guess though, Frank, what we need to sort of talk about at the start, well, this presupposes, doesn't it, that you actually have a valid bylaw?
It's a good start. So, and this is one of those things we see all the time, and this is the difficulty. So I suppose one of the services we absolutely offer, so blatant cross-promotional self-plug, is reviewing body corporate bylaws to make sure they're actually valid, because there is 0 point having a set of bylaws that you can't enforce. So Chris will post a link where you can upload your CMS and we'll have a look at them. But I suppose if you walk away from this with one thing in relation to registration of bylaws, is just because bylaws are registered does not mean they're valid. Surprise, surprise. You'd think if the government was going to register something at the Titles Office, and schedule senior bylaws, that it would be lawful, but that's not the case. So bylaws come into existence by usually someone throwing a motion to an agenda to change the bylaws, passed by special resolution. Body corporate's got a statutory obligation to register that within 3 months, and they do it. Now, in theory, there's probably a obligation of a body corporate to rule a motion out of order if it can't be given effect. Putting a bylaw up that is unlawful is probably one of those things, but that's a separate topic. But a lot of people don't know. So they want to have a bylaw. And Chris, I suppose let's play with some examples for the purposes of today. Let's go to pets, just for something completely uncontroversial.
Why not?
So they put up a bylaw that says no one shall be allowed to keep a pet. Now, the starting point is that's completely unlawful, because what bylaws can do is regulate the use of common property in lots. They can't be prohibitory in nature. So a bylaw that says you cannot, under Section 180 of the Act, is unlawful. So that bylaw might appear, and suddenly people think that's it. But if it's invalid, you can't do anything about it. By the same token, Chris, if you've got no bylaw, so if the bylaws are completely silent about needing to seek approval before someone brings a pet onto a lot or common property, then there's no need to seek approval, and there's nothing the committee or other owners can do about that. So, so assuming that you've actually got a valid bylaw, so that's the legal bit of this that we won't go into. And so let's go to a valid pet bylaw, which would say that you can't bring a pet into your lot or common property without the approval of the committee, and the pet can't cause a nuisance. And a condition of that is that the pet won't cause a nuisance to any owners or occupiers. Yep. So, you know, face value, legal bylaw, person goes and gets their approval, committee says sure, provided it doesn't cause the nuisance, which is consistent with the Act and the bylaw itself. And now we're into the vortex. So we have a valid bylaw. Let's talk about enforcing it.
We think that there are 5 essential steps in enforcing a bylaw, and these roughly equate to the flow chart that we'll put up. So the first step is there's an allegation made. I think that's reasonably self-explanatory. So you would hope that the committee would do that automatically, actually make the allegation happen. But there is provision for an owner or an occupier tenant to do that themselves, isn't there? And because it's an allegation, I think calling it allegation, we were quite specific about that, because with any allegation, you have to support it with evidence. So if I am to accuse Frank of whacking me over the head with a 2x4, that's one thing. But I've got to have something to back that up. Is there some video footage? Is there a weapon? Did somebody witness it? What happened?
The lump on your head where I got you?
All of the above. The facts. What are the facts of the situation? So let's take the pet barking, for example, Frank. So here we're talking, aren't we, logbooks, recordings, videos, but important that you make sure that you're pretty clear about what those things are, because presenting a sound recording of a dog barking does not necessarily mean it's that dog that you're complaining about.
Someone else's dog, yeah.
Maybe it's a dog from TV, for that matter.
Maybe it's a dog from down the street.
Yep.
I don't even know that's common property. So I suppose you do that with video at the same time, potentially, you know, but yeah, it is something factual that to hopefully a large degree is incontrovertible.
And there it is. Let's flip that around. Put it this way. If you're going to assume that the offending party is going to deny any wrongdoing, what can you present that makes it impossible for them to do so? That might actually be a really good way. Was that one of your inclusions, Frank? That's a good one. Yeah, I like that.
Logbooks, whatever it might be. And the other thing I think to be really important just with this particular point is that what the bylaws and the legislation actually should provide, well, bylaws should and legislation does provide for, is that the use of the lot or that nuisance is not unreasonably interfering with your use and enjoyment. So what to me that connotes, and I suppose if you've been a watcher of these webinars for a while, you've heard me say this before, but I'll say it again, is that in community living, there is going to be a degree of reasonable interference. So if the dog's yapping once or twice, that's not unreasonable. If it's yapping continuously for 6 hours a day, for example, and you've got logs and all that sort of stuff, then that is potentially getting towards unreasonable. So the allegation, Chris's dog barking unreasonably in terms of boom, 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 evidence, boom, 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 rather than Chris's dog is barking.
Yep. That's right. Which then leads us to point 2, which is what we call consideration. And simply making an allegation is one thing. Doesn't mean it's true, and it doesn't automatically follow that someone's going to get punished or penalised for it. At this point, the committee is being asked to consider, do they actually believe it's true? Has it been proven? And we actually think that this step throws the onus back on the accuser to pause for a moment and think, do we really want to proceed with this? I think that, so this is this is like step back, committee has to consider. So we'll use the dog barking one again. Someone has made an allegation that lot 1's dog is barking incessantly. That allegation's been presented to the committee. Some evidence, hopefully, has been presented as well. Then the committee has to have a think. Is the charge made out, to put it another way?
In a sense, absolutely. Are they going to take action with respect to it? And I suppose at that stage, it's not a very, this isn't something with which a committee needs to keep its blinkers purely on about, because at this stage, and I suppose this depends, and I suppose at the end of this month, we've got sort of gold-plated committees, and we'll start to lead into this a little bit. So it's not necessarily just for the committee to put its blinkers on and say, righto, there's the evidence, let's go get this guy or girl, whoever the owner or occupier might be. It might be for the committee to say, well, is there another way to solve this?
Yep.
Do any of them happen to know the person that's in the unit? Could they go and knock on the door and say, mate, we've had a complaint? Do they go and observe it for themselves to see if it's actually going on? Is there another way to deal with it rather than going DEFCON 1? And this is what, again, in a legal sense, I suppose we see, the bylaw breach notices all the time and that sort of stuff. And again, they're part of our daily existence. So in that sense, but I suppose they're not actually leveled at us either, which is a different thing, but we're used to them. Yeah. Actually firing one of those things at someone can be a declaration of war.
Absolutely.
So is that where the committee is willing to allow this to go without trying to explore alternative ways to deal with it? Absolutely. So it's an interesting question. Yep. So it's not just a black and white thing for a committee. Are we doing or are we not? Is there another way to approach this? But it certainly is. That's part of the consideration element of bylaw enforcement from a committee.
And I actually think, Frank, the legislation is framed for precisely that purpose, to give pause to think about a different way of potentially resolving it. That leads us then to step 3, which is decision time. So effectively, it's a yay or nay here from the committee. Committee has to either say yes or no. Yes, we agree with the allegation. No, we don't. And with new regulations in place from the 1st of March, there are some timeframes on the committee to make decisions. So they can't just leave that undecided for an indefinite period of time. If they do leave it undecided for a certain period of time, it's deemed to have failed anyway. It's also a yay or nay for the accuser, and this gives the accuser at that point a prompt, if you like, to think about what they do next. Because if the committee has said, yes, we agree, then there's an enforcement process for the committee to follow. But if the committee says, no, we don't agree that the allegation's been made out, that then opens up another avenue for the accuser to pursue at that point. So that's another decision at this stage as well. And it's really important that a decision come out at this point, because it's going to determine so many other courses of action, isn't it, Frank?
It is. And it's certainly, yeah, and this is a more black or white one. Is the committee going to do something or are they not? And to me, I think it's sort of really incumbent on committees, and this is really, back to acting reasonably, transparency and all that sort of stuff, is if a committee is or isn't going to do something, that they explain why. So hopefully as part of that consideration process, they've potentially engaged with the owner, they've assessed the evidence. So if they're not going to do something about it, to me, a reasonable committee would go back to the accuser and say, well, you know what, we're not, and this is why. Or if they are going to do something about it, it would be the same thing in terms of to the person you're about to have a go at, in a sense. Here's the bylaw breach notice, here's the basis on which it's been sent to you. Ideally, there's been an informal engagement beforehand. Might not be appropriate, subject to what the circumstances are. I mean, there's a whole lot of moving parts in these things, but it is. Then make a decision. And I think from a lot owner's perspective or an occupier's perspective, when asking the committees to enforce bylaws, it's now really important for that to be framed in the right way, so there's actually a motion for the committee to make a decision on, which will then enliven that deemed refusal component you were talking about before, if the committee does nothing. Because certainly, and this is, again, one of the other things we see with committees, and don't think Chris and I have been accusatory here for a second, well, certainly not Chris, because Chris isn't saying anything, is it can be a hard job. You are being asked by someone to have a go at someone else, effectively for them. So you're sitting there as a committee who's put your hand up potentially as a volunteer to just get involved and run some budgets and have some coffees and do some deal with the body corporate manager and maybe your on-site manager and all that sort of stuff. And you're being asked to potentially attack someone in their own home, which is not potentially a pleasant task. So previously, been very easy for committees to sort of stick their heads in the sand and hope it goes away and not make decisions. But now there's a real catalyst to make sure something happens.
That's right, Frank. So I think the decision and how it's delivered is really important at this stage. We then think that the next step, we've called this challenge, maybe a better way of calling this one is enforcing or administering, but anyway, we'll leave it as challenge for now.
Sort of bringing the parties together, isn't it? At this stage, we're stopping talking about it's not the accuser and it's not the committee. It's not, we're all going to come at this together because we're now all on the bus. We're on the bylaw enforcement bus.
And so at this point, one of two things happens. Either the committee proceeds with its enforcement of the bylaw, or if the committee refused in the previous step, the individual goes ahead and takes its own action. Now, that individual has two options at that point. They can take action against the committee for having refused to issue the breach notice. So that's option one. Option two, they take action directly against the offending party. So if we go back to our barking dog example, Frank, I've alleged that the dog is barking a lot. It's gone to the committee. Committee has decided, no, not enough evidence there. We're not going to enforce a breach notice about that dog. I'm not happy with that because the dog's still barking, or I think it's still barking. So my choice is at that stage, I can take action against the committee to reconsider or enforce, or I can take action direct against the person whose dog is barking. Now, that it may seem like a really attractive thing to do the latter, but if you are going to do that, you are obliged to undertake self-resolution directly with that person. That's confronting, very confronting, and it forces you back to that position where you have to try and resolve. It's a tough one, that one. And if the situation is still going at this stage, it's off to the Commissioner's office for conciliation, isn't it, Frank?
Yep, absolutely. And so to a degree, you can sort of outsource the enforcement mechanism to the committee, but if they're not going to do their own thing, then you've got to take it on yourself. So it's going to be you doing what you need to do, but there's still a mechanism to get there. And that's when everyone's on the bus and the conciliators will make you sit down and try to sort it out.
Question there, or a comment from Gleno. Gleno, thanks. If someone is breaking a bylaw, then they would not be having a go at you. Community living involves being mindful of others and following the rules. Agree. What we're talking about, though, is when you're on the committee and somebody makes an accusation that somebody is breaching a bylaw, and you as the committee are effectively in the position of delivering that news, if you like, to that person. We think that that's actually having a go is, I guess, our colloquial way of saying it, but you are in effect delivering them a message that you think that they have breached laws, and they might disagree, and disagree for a whole host of reasons.
And one of the other assumptions is to actually know there are bylaws.
Yes, that's a big assumption to make.
Respectfully, Glenn, there's lots of people that don't know bylaws exist and how the system works.
Absolutely. The very last step in the process is there's a dispute. So you've gone through all the preceding steps, you've been off to conciliation, it either hasn't worked or it hasn't worked as well as you want. You're then off to adjudication to get an order. All well and good, and you might think, that's great, that's going to solve my barking dog, but let's just say you do get the order that the dog is barking. What are you going to do about it then? Say the adjudicator orders the removal of the dog. We've certainly seen that happen in some orders. Who's going to remove it? The next step then after that, which we're not really covering today, is you have to toddle on off to the magistrate's court to get it enforced. The magistrate's court is going to have to appoint somebody to come and physically remove the animal.
We had that in a very long-running dispute. It's extraordinary. And I suppose over that whole process, it was about 18 months.
Yep.
So there wasn't resolution, and we're acting for the body corporate in that one. The resolution was just, it took forever. And eventually the owner moved out and took the dogs with her.
Yep. That's a huge investment of time, energy, resources, and emotion. And really, that's why we have been really careful to say at every step, you need to be considering very carefully if this is right for you and your circumstances, because you've got to remember that's the end game. If at every step of the way, the party who you're complaining against resists and denies, this is ultimately what you are up against. Okay, Frank, all of that in mind, what are the other ways of resolving? What are the alternatives here?
Oh, look, I think it's communication again. We keep coming back to this. It's not just hoping that people do know the rules or know there are rules to start with, and then that they know them actually, that they're following them. To me, it's that communication piece, and this is sort of the default position that I think a lot of committees potentially could be forced into or should be dealing with, is engaging with people around what they are. And it's also what the rules are, and it's how do you communicate to people what the rules are. Is there a summary of the bylaws? So there's a bunch of bylaws that probably don't have a whole lot of relevance. There's some that are going to, and probably you'd almost summarize into one page the key things that we see as being disputes about bylaws from time to time. The start is letting everyone know, owners and occupiers, that these are the rules. This is how they work. And then ideally, and this is one of the things that I still can't see happening in Strata the way I think it almost should be, is almost communication portals for occupiers in a building about what's going on in that building. Some resident managers who become that focal point, let everyone know what's going on, because in a body corporate context, everyone's usually got the owner's details, but not everyone has the occupier's details. And as much as there's an obligation to have them on the roll, if a building's full of tenants, no one might actually know who they are. So how do you actually communicate with those people about the same rules that are actually there?
Well said, Frank. Comment there from Peter. Peter, long time no speak. Is the system so clunky and stressful that it's better to attempt face-to-face, and if that fails, just move, or is that too pessimistic? No, I think you're being quite realistic up to a point, Peter. I'll throw to you in a minute, Frank. Absolutely, you should always attempt face-to-face. I always add the qualifier if it's safe to do so. There are instances where it's just not a good idea to have a face-to-face discussion with someone about a problem in a body corporate. If that fails, just move. Gosh, what do you think, Frank?
Or change your expectations.
Yep.
Is one of the other things. One of the things that never really goes well in bylaws is militaristic approaches to them. This is scorched earth policy, let's go. The reality is, and that's that community living, it involves compromise. It involves being accepting of other people's foibles, issues, cooking, pet habits. So sometimes it's a matter of not letting things get to you as well. But absolutely. And the problem, I suppose, with moving is if you move to a smaller, maybe you're not on acreage, you're on a small block somewhere, the person with the barking dog next door, you've got no rights at all with respect to.
That's
at least
right.
in a body corporate, there's something, as much as it might be a little bit convoluted, to actually get you where you want to go.
Well, I mean, like Frank, you live in a house. I'm in a community title scheme myself. I know that I have had issues with the apartment complex next door to where I live with some noise issues. But what are my options there? I'm not part of that building. It's not up to me. Same with you, like your neighbours. If your neighbours are irritating you on any given day, what are you going to do about it?
Thankfully, he's 90.
Nah, well.
So he's very quiet. But it's funny. It's almost the be careful what you wish for type thing, isn't it? Sometimes.
Absolutely. We have just put up the link there to the flow chart that we've been talking about the whole time today. So this is the flow chart. Full credit where credit is due. This is the Commissioner's Office has done this. It's on their website. In addition to the flow chart, there is a lot of information that goes with it, and I urge anybody who's about to embark on bylaw enforcement or thinks that they're about to embark on bylaw enforcement, have a look, have a really careful read of what's there, and just be sure you know what you're getting yourself in for before you do it. I think that's probably...
If you're going to run it yourself, you absolutely have to. Obviously, got lawyers, that's fine. You rely on the lawyers to do it. But if you don't follow that, you are not going to get there.
That's right.
And from start to finish, I suppose, today, with what we know is going on in the Commissioner's office in terms of volume and the rest of it, it's a 12-month process from when you actually probably get the initial starting of the complaint through to the processes before actual enforcement we spoke about today, towards filing application, conciliation, and eventually a decision. That's the reality of it.
That's right, Frank. So think about the alternatives, I think, is the message we'd like to leave you with today. As always, don't forget to register, like and share, fire us some questions. If you have some further queries, drop us a line, info@hineslegal.com.au. Next week, Frank, where good body corporate managers go wrong.
I just try to make sure we stay very on that fence where we don't cop spears from everyone, but that'll be fun.
Look, no, that'll be a good one for everyone. I think managers included, I would suggest. So stay tuned for that. Hopefully by the time we deliver this next week, we will be out of lockdown, but who knows? Anyway, in the interim, for everybody watching, if you are in lockdown, I hope the next couple of days go okay for everyone. Until then, Frank, thank you very much.
See you everyone. Thanks for joining us.
Thanks everyone for joining us today. Much appreciated.